Hello, welcome to the Arbitration Conversation. So in this arbitration conversation, we're finally going to talk about ad hoc arbitration and also about student adjudicatory processes. So some different topics from a very practical standpoint with a true leader in the area and someone who really has just an outstanding background. I feel very honored that we have her honor, the former Justice of the Iowa Supreme Court, Marsha Ternus. Marsha Ternus is a perfect example of someone who has been a dispute resolution provider really throughout her career, but also having that expertise, not only in private practice, but also actually serving on the Iowa Supreme Court. So Marsha, thank you for taking time with us. I know how busy you are.
Hi, Amy. Thank you for having me. It's fun to be here. I
Well,
think we'll
cool.
see.
Yeah, you'll wait and see. Well, the cool thing is too, Marsha lives in Des Moines, Iowa, and I lived in Des Moines, Iowa for 4 years. And so prior to taping, we got to talk a little bit about Des Moines and all the changes there, which is also a really cool subject. But today we're
Yeah.
talking about arbitration. So I first of all wanted to ask you kind of when you made the decision to move to doing more counsel and also, of course, with arbitration itself and doing the student adjudications out of the Iowa Supreme Court.
Mhm.
What was the journey like for you to make that decision?
Well, I really didn't make the decision to leave the court. I was one of the three justices who were voted out in 2010 because of our decision in the same sex marriage case. So I found myself with the opportunity to have a really vibrant third chapter in my career while I was still relatively young. I was in my late 50s when that happened. And of course, I love judging, I love writing decisions. And so it seemed a natural um, avenue for me to take. And so I've just over time tried to build up an arbitration practice. I must say, I did try mediation because there was really much more demand for that, at least initially, and even now, I'm sure. But I just wasn't cut out for the, um, some people would say the diplomacy required. I kind of felt like it was the manipulation that was required. I just didn't take to that at all. But
Well,
arbitration, I love.
and people do actually call mediation benign manipulation
Oh, do
because,
they? Yeah,
yeah.
I agree.
So what you're saying is absolutely true, no question. Yeah, and of course, the thing about arbitration is there's so many different areas that often we don't even talk about. And one of those areas is really student conduct proceedings. I
Mhm,
would love it if you could explain how that works and sort of the practical aspects of
mhm.
student conduct proceedings.
Yeah. Well, generally, if I'm asked to participate in a student conduct misconduct hearing, it's because it's a Title IX case. And the hearings have evolved over the last 10 years because of different guidances and regulations from the Department of Education, the Federal Department of Education. So they're not exactly like an arbitration. There are generally not attorneys, but you do have a meeting or hearing where the parties give their version of facts. There's generally quite a thorough investigation that is done before the hearing, and the adjudicator gets the report from the investigator. And then, of course, you evaluate the evidence, weigh the facts, make decisions on the disputed issues, and then determine whether there is responsibility for the alleged misconduct, and write up a decision really just like any trial judge or Supreme Court judge would write. So the process is a little different, but the I think the skill set is clearly what you would expect from an arbitrator.
Oh, 100%. I mean, I think it's a perfect example of an area that really is essentially arbitration and that
Mm-hmm,
you're not going to a court of law, but the process is absolutely the same. And
mm-hmm,
also in handling other arbitrations, what does it mean for an arbitration? And again, maybe those watching this, they're not really sure kind of where things fit in because so many times people hear about AAA arbitration or
mm-hmm.
JAMS arbitration. What does it mean for an arbitration to be ad hoc?
Well, when When I talk about myself doing ad hoc arbitration, it means that two attorneys or their clients have agreed on arbitration either pre-dispute or after the dispute has arisen. There's no requirement in the arbitration agreement that they go through a certain entity. Although I have actually done arbitrations where the contract does require them to use AAA and they just decide they don't want to go through that expense, take that route. So it's just people who want to arbitrate and they come to me and ask me if I will do it. So it's even more ad hoc in the sense that we have oftentimes a blank slate in terms of how we want to conduct the arbitration. There are generally some parameters in, especially in pre-dispute arbitration agreements. They might refer to a specific set of rules that are going to be followed, or some process for appointing arbitrators, or just, a variety of things that they could agree on ahead of time. But by and large, they come to me without a lot of decision making ahead of time in terms of the process. So I work with the attorneys and find out, is speed of the essence? Do you want to do this like, are we doing civil litigation through arbitration, or are we really going to arbitrate and try to take advantage of the simplicity and the speed that it can be done with? So it's fun. It's fun because you get to work closely with attorneys, and generally it's been pretty. People are pretty accommodating, but sometimes you get an arbitration and you might as well be in court.
Yeah, we've talked, in fact, with my class, I've talked about the judicialization of arbitration when it sort of becomes very judicialized.
Yeah, and I don't see the point of that. Well, I guess now I can kind of see the point of it because civil trials are going to be so delayed that even people who want the whole civil litigation process may need an answer sooner than they're going to get it in court. And I
Yeah,
think that's particularly true with business litigation. How do you plan for the future, where to make investments, what staff you need? If you have some uh, commercial dispute looming over your head, you need to get that decided and out of the way. So I see more of that than I think other types of cases, although all of these nursing home, retirement home contracts seem to have an arbitration clause. So I've done several of those too.
and have you seen, and now sort of thinking about the practical aspects with, of course, COVID-19 pandemic, which, as you mentioned, courts are going to be very delayed for a long time to catch up. Have you seen a growth in these kind of submission agreements also, where people are actually agreeing post-dispute to go ahead and arbitrate?
I am beginning to see that. Yeah, I didn't see it much at the like until the end of 2020 because I think there was still hope that courts could get up and running. But I know here in Des Moines, they're setting trial dates last year, like at the end of 2020, they were setting trial dates for 2022. And so that's what's getting lawyers thinking, if we can't get this settled, maybe we should just arbitrate. But I think they have to think long and hard about the expense of that, really, because um, they have to pay the arbitrator, and if they're going to have discovery disputes and um, bring in every witness, it can really add up for cost. But the one I just did one a couple weeks ago, and they had agreed they would bring the primary witnesses in person. All other witnesses would be by statement. And so I think that there are ways to streamline even complex cases. And this case was very complex. It took 4 days, which I know some take weeks, but there were just a lot of issues and a lot of facts to be developed.
And so did you actually conduct it virtually then, or
Mhm.
how was this, I'm guessing?
Virtually. Mhm.
That's a
Mhm.
lot of time online. I wonder, do you have any advice for sort of screen fatigue, right? Because
Yeah.
I imagine in a long term, very complex arbitration, that would mean a lot of time on Zoom.
Mhm.
Even,
Well,
yeah, what do you
yeah, we've tried to take breaks at logical times, but generally we had a morning break, a lunch break, and an afternoon break. But the nature of the case was that there were a lot of documents that were being discussed. And so it wasn't just the parties and the attorneys and me looking at each other with the occasional witness coming in, um, and just hearing questions. There was a lot of documents being put up. Both attorneys were very skilled in being able to use the technology, and so it was very easy to share screens. And they'd put something up, and they'd blow it up, and switch to another document. And so I think maybe that kept it more energized than if it were just witnesses without the screen ever changing.
Mhm.
So we really didn't find it necessary to take a lot of breaks, just a morning and an afternoon break, and everybody seemed to be fine. We never did, for various scheduling reasons, have a day that went very late. I think the latest maybe we went in any given day was 3 or 3:30, so that probably made a difference too.
Well, and do you have any sort of practical advice for attorneys as they're thinking about um, really how they would present their case in these virtual arbitrations that are, of course, happening everywhere right now, and probably here to stay given the cost differences? Do you have any sort of practical advice?
Well, I think that the most practical advice I can give to them is that before they get very far into the arbitration, it's really good to develop some rapport with the other attorney and try to agree ahead of time on doing things the easy way so that it goes smoothly and quickly. Because I'm still assuming that if people want to arbitrate, they want to arbitrate to get the advantages of arbitration. Now, as I said, I think there will be some people who will want just to do civil litigation through arbitration. But if you're trying to use arbitration for the advantages, then I think it's really important to talk ahead of time. Decide things like, can we put in expert evidence with a report? How many depositions do we want to do here? And a lot of those practical decisions can be made before you ever get to the arbitrator. Now, once they get to me, if they can't agree, I'm happy to make decisions. That's what they pay me for. But I think things will go smoother and cost your client less if you take that approach to arbitration. And then during the hearing, I really don't see it being much different than how you would try a case live. I really don't. The only difference, and this is significant, of course, you've got to become comfortable with the technology so that you feel comfortable um, talking to a screen. And importantly, if you're going to have exhibits, then you need to have those ready to go. You need to practice ahead of time. I mean, one of these attorneys, he could do all kinds of things with documents and draw circles around things and really use it in an aggressive, energized way. And I think that helps the presentation of your case, and probably even more when it is virtual.
Yeah,
So
yeah.
practicing that would be good.
Oh,
Yeah.
absolutely. That just, I mean, and it shows how, really having these skills to be able to use the technology becomes really important. I guess, lastly, do you have any recommendations going to that question of technology? Another question that comes up from a practical standpoint is when do you think an attorney should maybe hire somebody to be their technical help? For example, I know how some new businesses have actually popped up where they're helping with the technology.
Yeah, that's true. Well, I think if you are not comfortable with the technology and you don't feel capable or have the desire to become um, competent using it, and it is a case that involves a lot of documents, then yeah, you probably need somebody to assist you. And it may just be a younger person in the firm. You may not have to hire somebody outside the firm. And I have seen that. Did have a hearing where a younger person in the firm was kind of serving as the tech guy with documents. So that certainly I mean, that's a cost, I suppose, but not as much as if you would go outside the firm. But I think it's a personal decision. But certainly if there's a lot of documents and you're not up to managing them, yeah,
I
you better have somebody, because you do not want everybody to sit there while you stumble along. That would make a hearing, it would lengthen it, it would be aggravating, it would be costly because you're just wasting time.
No, that's a great point. And it also just kind of emphasizes, I know I say this for my students as well, to think about the opportunities they might have in arbitration because of their ability to work with the technology. So it's good to hear about.
Yes, absolutely. And I think even when the pandemic is over, that a lot of this will continue to be done virtually. It is so convenient. And it is particularly helpful if you have witnesses from around the state or around the country. Um, they can come in via Zoom or whatever platform that you are using. And it's convenient for them, and they're much happier to testify because it is convenient. It's just a good, um, it's a good way to do it for a lot of reasons besides safety.
Well, that's near and dear to my heart, being a proponent of OARB for a long time. So thank you for adding that.
Yeah. Oh, I love it. I really do. And a lot of my adjudications, going back years, have always been virtual because oftentimes students aren't, they're either not still on campus, or it's spring break when you're doing it, or it's over the summer when you have the hearing. And so they're off to wherever they're from. And so I've done virtual hearings for years and years. And I should just say that because maybe it colors my comfort. It surely helps me in terms of my comfort level. But I do think that with use, anybody would really enjoy the convenience of it. And I think that I don't feel that I lose very much in terms of judging credibility by not seeing body language. I mean, who do judges think they are? I mean, there are some people who just by their body language, you think, boy, they're uncomfortable. But why are they uncomfortable? Because they're lying, or because they're just intimidated by the situation? So um, I think that there are a lot of ways to judge credibility in addition to the demeanor and what you see on the screen. And so whatever little clues you might lose by not having an in-person experience, I think are very, very minimal.
Yeah, that's a great point. And I'm glad you brought up the student adjudications, because the other piece I would imagine is it lowers the stress for the student, I would think, when they're not in person, because that's got to be a very scary situation for those
Mhm,
students as well
mhm.
in person.
Yeah, totally. Yeah. I will say this for the Title IX adjudications, they're never in the same room at the same time. Um, at, but the ones we have been doing recently, they're virtually in the same meeting at the same time. And I think it does help a lot when they're not testifying. I let them turn off their video.
Mhm.
They're still connected with audio. And so that's a huge pressure release, I think, for them, just to be able to listen but not be in the same room and not have their video showing. So yeah, virtual hearings in those situations, I think, are really, really a good thing.
Yeah, absolutely. Well, I have to tell you, this has been really helpful. There's so many pieces that have been really helpful, and I'm so thankful that you took time, because this is really, really great. Also, I should note we're going to be speaking together on a panel coming
Mhm.
up with the Creighton Law Review Symposium. So I'm looking forward to that as well.
Me too. Me too.